I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really
Welcome back, everyone. Today's case is one of the most explosive hearings we've covered on this channel. What starts as a straightforward landlord-tenant dispute spirals into a full-blown courtroom meltdown, complete with attitude clashes, warnings from the bench, and a judge whose patience gets tested in real time. We're about to watch how a $4,298 balance, a rental assistance program, and one tense exchange push this hearing right to the edge. But here's where it gets even more gripping. This case isn't just about unpaid rent. It's about communication breakdowns, deadlines, rapid rehousing programs, and the pressure that real-life financial hardship puts on people already barely holding things together. And your reaction might surprise you, because depending on how you look at it, both sides have compelling arguments. As we move through the hearing, pay close attention to the judge's tone shifts. You'll see exactly when things start turning, why the courtroom atmosphere changes instantly, and how fast a judge will shut down interruptions when things get out of hand. Trust me, the moment it happens you'll feel it. Now buckle up, because the energy in this courtroom doesn't build slowly, it hits almost immediately. Let's jump into it.
court does call the case of Mill Pond Manor versus, is it Changming Fan?
Yes, Your Honor.
Good
Yes,
morning. Good morning, Your Honor. James Martone appearing on behalf of the plaintiff.
Good morning, Your Honor. Student attorney Calvin O'Connell, joined by my partner Allison Futter and our supervisor Sarah Sallin from the University of Michigan Civil Criminal Law Clinic on behalf of our client, Mr.
Boy,
Fan.
that's a long intro. Go.
Apologies,
No,
Your Honor,
go,
but
go on.
there is more. We
There's
are,
more.
I
Okay,
know,
go for it. I got all morning.
we are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Ms. Sallin.
You know, have you been before me? Damp there. It's like rain, just rain. It's just I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
Oh, is that different? That's different than UW.
No, that is UW, Your Honor.
Is it? They're in Seattle?
Yes, North Seattle.
You understand that they beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here in Michigan now. That's where my allegiance.
You didn't belong in the game. Listen. Anyway, I'm I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Miss Sullivan. No.
good morning, Judge.
All right. What are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move for summary disposition in this case on the basis of what we believe are multiple park forest violations. Attached to our motion are exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow. Um, all of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. So, and I will note, just briefly for the court, that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag.
This right here is one of the most intense moments in the entire hearing. The judge's reaction isn't coming out of nowhere. Courtrooms rely heavily on decorum, and when a defendant interrupts, talks over the court, or becomes visibly frustrated, judges often view it as a direct challenge to their authority. That's why Judge Simpson's tone shifts sharply. He isn't reacting just to the words, he's reacting to what it represents: loss of order. But think about the emotional context here. Keir is facing eviction, managing children, relying on public assistance programs, and trying to navigate paperwork deadlines that can feel impossible when you don't have a car or stable income. Many people watching this will empathize deeply with her frustration. Still, frustration and courtroom etiquette don't mix. The judge has to control the room, and even a moment of pushback can set off consequences, as you just saw. This is a great moment to ask you all. Do you think the judge was justified in removing her from the courtroom, or should he have given more grace considering her circumstances? Let us know in the comments, because this is one of those scenes where the room is split right down the middle.
That for the court, in case he does become unavailable momentarily. But in any event, for the sake of his health and, on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor,
Yes, go ahead.
if I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
Yeah, go ahead.
We have been engaged with Mr. Fan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Fan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Fan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Fan was led to believe that acceptance of rent or other actions waived that termination of tenancy notice. In fact, at all
I think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no. Is it possible to? Do you need an answer date or a hearing date?
Yeah. Well, I just need. How much time are you going to need to file an answer, and then I can give you a hearing date?
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No,
Oh, Tuesday, sorry. December 2nd, after that.
that's my next day.
I'm sorry, November 18th.
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and make it, and then we'll see whether we go forward.
Thank you,
All
Your
right.
Honor.
All
Judge,
right. Thank
Judge,
you.
I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Fan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate?
My short answer would be no, but give me, you have it,
I do, that was filed as a general civil matter.
so it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing has
There's
gone
no
forward on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over because it doesn't make sense to, I don't know what the issues are in that filing. But it would seem to me that if they relate to the tenancy, it would be best that it be handled in one place. So
And it looks like
I will talk to Judge Barr about that, and then we'll deal with it on the 18th.
Thank you, Your Honor. I appreciate it.
All right. Okay. Thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
This case ended with a clear legal takeaway. Regardless of personal hardships, the court must base its decisions on documented facts, deadlines, and conduct within the courtroom. The judge issued a judgment for possession but also gave Keir a significant opportunity, a redemption window lasting until August 4, 2025, to pay the full $4,298.39 and keep her home. That's a long timeline and a noteworthy act of judicial leniency. From a legal perspective, the ruling balanced tenant support programs like SOS with the landlord's right to timely rent payments. And while the emotional tension of this hearing could have derailed everything, the final judgment still gave Keir a path to avoid eviction if she secured the assistance she claimed was in motion. So now we turn it to you. Was this outcome fair? What would you have ruled if you were on the bench? Do you think more time, more patience, or stricter consequences were warranted? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.